I'll just get started here. So good evening and welcome everyone. My name is Warren Bloom. I'm the Vice President of Events for the Texas Federalist Society. I couldn't be more thrilled tonight to introduce our speakers for our event, Section 230 and Big Tech, Big Problem. But first, a quick plug. For those of you out there who are not yet members of the Texas Federalist Society, please go to our website at texasfedsoc.org and join. Membership costs $5, but being a member is priceless. Now for introductions. First with Professor Volek. Professor Eugene Volek teaches First Amendment law and a First Amendment amicus brief clinic at the UCLA School of Law. He's also the founder and co-author of The Volek Conspiracy, a leading legal blog. If you've never heard of it, first, be ashamed, and second, go look it up. Professor Volek worked as a computer programmer before graduated from UCLA with a BS in math science, computer science, at the age of 15. Yeah. 9 years later, at the ripe old age of 24, Professor Volek graduated from UCLA Law, after which he began his legal career modestly, clerking first for Judge Alex Kozinski on the Ninth Circuit, and then for Justice Sandra Day O'Connor. Also fleeing to Texas tonight is another Californian, Professor Ash Bhagwat of the UC Davis School of Law. He's the author of numerous books and articles and book chapters on a wide variety of subjects, ranging from the structure of constitutional rights to free speech law to the California electricity crisis. Professor Bhagwat is a summa cum laude graduate of Yale University, where he received a BA in history. He's also a graduate of the University of Chicago School of Law School, not School of Law. Like Professor Volek, Professor Bhagwat began his legal career modestly, clerking first for Judge Richard Posner on the Seventh Circuit, and then for Justice Anthony Kennedy. Now I'll turn it over to Professor Volek to start us off with a quick summary of what Section 230 is, what it isn't, and what he thinks the law should be. Then Professor Bhagwat will share his thoughts, and after some back and forth between them, I'll moderate a Q&A session. So please submit questions throughout the conversation that you'd like me to ask our guests. Gentlemen, thank you for joining us, and Professor Volek, the floor is yours.
Thank you very much for having me. I very much appreciate your putting on this event, and it's always a great pleasure to be on with Ash. So you ask what 230 is, and it's basically two things, basically, when we boil it down. One section, which I think we're not going to spend a lot of time talking about, although we might, I'm always up for it, is 230C1. And 230C1 basically says that platforms have a right to have people post things on it without being responsible for what the people post. And that's really what allowed Facebook and probably Google search and Twitter and the like to exist, YouTube as well. Imagine that whenever somebody posts something defamatory on Twitter, I think it happens every so often, Twitter would be held legally liable for that. And that would make it for a hard business model, especially for a business that doesn't charge money for people to sign up. One sec. Sorry. So 230C1 says no service provider shall be liable as a speaker or a publisher for material that is posted there. And courts have basically read this as absolute immunity. They've basically said that, in a sense, internet platforms are like the phone company, right? The phone company is not liable for defamation or invasion of privacy or negligence or whatever by its users. That's true even if it knows that some phone line is being used to spread libels. There's a case on that from the 1970s where there was an outgoing answering machine message which was allegedly libelous. The phone company was alerted to this and it said, none of our business, none of our business. So Twitter and Facebook and Google running YouTube are entitled to say none of our business if somebody complains saying something is libelous. So that's 230C1. Well, so 230C2 bears, I think, perhaps a little bit more kind of textual discussion. And let me share the screen that has an image of that. 230C2 says that, well, Platforms are not liable for what's posted on them. Neither are they liable when they refuse to post things. I oversimplify here, but I think basically that's the soundest way of treating the two sections. So no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that they consider to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. So remember I said Twitter, Facebook, and such are like a phone company in being immune? That's true, but they're like a bookstore in having at least considerable discretion. We can talk about whether it's unlimited discretion, but at least considerable discretion in deciding what to allow on shelves. So historically, if you were running a bookstore, you had this kind of editorial discretion or selection discretion, but you could be liable for defamation in books you sell, at least once you're alerted to the book being potentially defamatory. And if you were running a phone company, then you had complete immunity from libel about based on what is said on the phone lines. But at the same time, you didn't have editorial discretion because you're a common carrier. You weren't allowed to shut down someone's phone line because you don't like its content. And Section 230, basically, deliberate congressional choice says to online service providers, you get the best of both worlds. You get the immunities of a phone company and the editorial judgment, the selection judgment of a bookstore. So that's what Section 230, at least as I understand, is mostly about. There are various questions about it. One is it a good idea? Maybe it wasn't a good idea. Maybe it was a good idea, but isn't a good idea now that Facebook and Twitter, especially Facebook, are a mega corporation, and maybe they can police things for defamation and the like. Maybe. Another question is maybe Section 230 shouldn't give these service providers the rights of a bookstore to pick and choose what to allow on its shelves. Maybe they should be treated kind of like a phone company as a common carrier. And another question is to ask, what does 230C2 really mean when it says otherwise objectionable? Does it mean that a platform has the right, notwithstanding any state law that might, for example, try to mandate that the platform not discriminate? Does it mean the platform nonetheless has the right to say, we find certain material objectionable, politically objectionable, whatever else, ideologically objectionable, we just don't like it, we're gonna eject it, again, the way a bookstore can? Or does that list of things on the screen help illustrate what otherwise objectionable means? And under the interpretive canon of so-called ejusdem generis, should otherwise objectionable to mean objectionable in ways those other things are objectionable? And if so, what are those ways? So that's an interesting interpretive question. One other question, which I think Ash and I are probably going to get to, is even setting aside Section 230, what does the First Amendment tell us about this? Maybe even without 230C2, platforms have the right to pick and choose just under the First Amendment what goes on, what is allowed on the platform, just like a newspaper has that right. Maybe even without 230C1, maybe platforms should get very broad immunity against libel, maybe even broader than newspapers get because they host so much material. These are all interesting questions, but you asked what's 230, so I wanted to briefly tell the listeners what 230 is. Ash, I think it's your turn.
Okay, I completely agree with everything Eugene just said in terms of description, so I'm not going to repeat it. I am going to take a position that is very strongly supportive of 230, largely as it is today. I know there's been a lot of sort of calls for reform of 230, and I think most of them are exaggerated or a bad idea, honestly. I'm going to start off by just making a point, which is several academics, including my former colleague Anupam Chandler, argued. I am quite convinced that the success of the internet in the United States, I mean, we invented the technology, so it's not surprising the internet grew here. But the fact that essentially all internet giants are American companies, except for the Chinese ones who were shielded from American competition, is not a coincidence. And it is tied to two things. One of them is a California thing, which is the fact that covenants not to compete are not enforced in California, which means that it's much easier to leave a firm and make us create a startup. But the other, and that's, which is, the argument is that's why Silicon Valley is in California and not in some other state. Stanford, of course, being the other reason. But the other reason is the First Amendment, that we protect speech much more vigorously than most other industrialized countries, notably much more vigorously than Europe, and that gave space for internet companies to grow, and that 230 to some extent doubles down on the First Amendment because it goes beyond, arguably, what the First Amendment requires. And therefore, it's the 22 words that made the internet. 22, I think that's the number, is what 230 is often called. Second, I want to argue that in many ways, large aspects of Section 230, I believe, are compelled by the First Amendment. Not all, concededly, but large amounts. Section 1, for example, which grants immunity for basically material that Facebook allows users to post, that I'm using Facebook as the example, users to post that turns out to be defamatory or something like that. In my view, for the same reason that we limit defamation liability for newspapers, see New York Times versus Sullivan, for those of you who have taken First Amendment law, the First Amendment compels us to do the same for a third-party platform like Facebook or Twitter, because otherwise the platform, and the chilling effect otherwise would be complete. You really can't have a platform with third-party content if you don't have some form of immunity. Now, as with Sullivan, I think that the courts may have gone further than the First Amendment requires, in that they also provide immunity even when the platform knows that content is illegal, such as defamatory content. That's probably not required by the First Amendment. Also, it may not be required by actually the proper reading of Section 1. Justice Thomas wrote in 2020, Justice Thomas wrote a separate opinion in a denial from cert in a case called Malwarebyte, in which he argued that the courts and lower courts have misinterpreted Section 1, that Section 1 does not prohibit imposing liability on platforms for third-party content that they know is illegal. I am okay with that. Like I said, in some ways I think that there are reforms to 230 I can imagine. I think that liability for knowing distribution, I'm okay with, because for obvious reasons, because I mean, defamation hurts people, threats hurt people, so on and so forth. But I think the word knowing is a very, very tricky word. And the reason is that what I fear is that courts will say that because Facebook has this enormous content moderation apparatus, it knows or should have known about essentially all illegal conduct. And I think that's a disastrous way to go. Because the reality is content moderation is always has holes in it, always will. Maybe not always, maybe AI will become perfect in 30 years, but I think in today's world, realistically, stuff is going to get through. That Facebook doesn't want to get through, that is unprotected and so forth. And so I think that we need to be very, very careful that we don't kill the goose that laid the golden egg. So that's Section 1. Section 2, the one that Professor Volokh put on the screen, which grants immunity for editorial choices, I also think is largely compelled by the First Amendment, because I believe that platforms like Facebook and Twitter and YouTube clearly have some First Amendment right to control what they choose to distribute and not distribute. And that they're not exactly like newspapers, but they're more analogous to newspapers than they are to telephone companies. I would add that I think this is a very, very good thing. And I think that recent proposals to try and make them into effectively telephone companies, common carriers, is a terrible idea. And the reason is people post awful stuff. Some of it gets through. I've had friends share threats they received on Facebook and sort of all sorts of just sort of misogynistic or racist stuff. But at least Facebook today has some mechanism to try and control it. In a world of common carriers, unless it's an actual physical threat, hate speech is protected speech. Most pornography is protected speech. I think that we would end up drowning in content that Eric Goldman at Santa Clara calls awful but lawful. And I don't see why anyone would want that. And finally, so I want to talk about this otherwise objectionable issue. I agree, statutorily, it's a very difficult question. Whether otherwise objectionable should be limited to things like obscenity and harassment, or whether it should be more broad. But to give you one example, as famously, I think all of the social media platforms, but certainly Facebook, treats vaccine disinformation as speech that it's going to remove. Those are the kinds of judgments that I think we have to let Facebook make. If we interpret otherwise objectionable to mean only things like obscenity, Facebook would lose a lot of capacity to remove content. One of the things that what about ISIS propaganda? Is that otherwise objectionable? I think it is, but and certainly Facebook doesn't permit it. But it's not clear to me under the broad and narrower reading of Section 230 that some have proposed that ISIS propaganda could be removed, because it's not, unless it actually shows violence, it's just a political perspective, an awful one, but it's a political perspective. I think I'll stop talking there.
So Asha, I think there's a great deal to what you say, and it may be on balance, you're quite right. And certainly, as to any particular kind of statement, we could say, isn't it good that Facebook blocks this bad thing or that bad thing? And maybe we say, okay, maybe the government shouldn't do it, shouldn't throw you in jail for it. But if you just can't spread it on Facebook or on Twitter or on YouTube or on any other platform that big tech kind of pushes around into implementing similar rules like it's been trying to do with Parler, what's the big deal? You're not being thrown in jail. If you want to, you can find some way of communicating. And if it's hard for you to communicate it, all to the good. Maybe, and one possible understanding of free speech is that freedom of speech in America has always been constrained in part by kind of social norms and important and kind of powerful business enterprises, mostly the media. And that maybe that a model where you get this kind of mix of social and business and controlled by basically wealthy organizations is better than either governmental control or no control at all, where really everybody says anything they want to, and without much expense and without having to get anybody's permission. Maybe that's a plausible thing. But I gotta say, I'm kind of worried about having these super powerful, wealthy corporations who are in a position where they get to pick and choose what's vaccine disinformation. I'm all for the vaccine, all for all sorts of vaccines. I'm very happy to take them. I'll take the booster if they offer the booster, but the power to block vaccine disinformation, which probably includes, as I understand it, not just outright falsehoods, but also opinions that they think are unsound. That could be a power to block all sorts of things that they think are bad for various reasons. Maybe today, many people might like the editorial judgment that Mark Zuckerberg and the people he trusts impose, but I'm not sure why we should think about that. Why we should take that view indefinitely. So I wanted to ask you what you thought of Justice Stevens's opinion in Citizens United. And actually, I should know this. Maybe you're on the record on this. We've never really talked about Citizens United. I'm actually a supporter of the majority in Citizens United. I think that corporations should have the right to spend money in order to speak for or against candidates or for or against anything else. But I do think that Justice Stevens had a pretty powerful argument when he took the opposite view. He and three other justices took the opposite view, that allowing essentially corporations to leverage their economic power into political power is dangerous for democracy. It may give corporations unfair influence in the electoral process and distort public debate in various ways. I part ways with him when he says that's an adequate basis for barring corporations even from speaking, because that's what his position would have meant, that a corporation couldn't use its general funds even to speak, at least about candidates. For example, to put out fact checks, to give an analogy to Twitter or something like that. But I would think that his argument, even though I don't buy it when it comes to restrictions on corporate speech, it seems to me it seems to me, is very powerful when corporations aren't just speaking, but are actually restricting the speech that is said on, to be sure, on their services, but tremendously important services. So I think on this point, I got to admit, the left has a point. The left has long been much more concerned than the right about private power. I think some of that concern has been overstated. But when it gets to be the kind of power that Facebook especially has, and Google is to YouTube and Twitter and such, especially in a closely divided country where even if you don't totally ban something, but you remove it from that kind of big platform, it could really change the course of an election. That seems to be something quite troubling. And maybe the cost that it imposes is greater than whatever benefit we get from it cleaning up this awful speech. So what do you think about that? First of all, tell me again, I just don't remember, what was your view on Citizens United? What is your view on Citizens United? And what do you think about this problem, if you think it's a problem, of private power, of these private organizations leveraging their stupendous economic power into political power?
Great questions and fair. So I've never written about Citizens United because I don't find it honestly that interesting, because I describe myself as the only Democrat in America who believes that not only was Citizens United right, it was obviously right. The idea that the government can decide someone is too loud and shut them up just cannot be right. And especially when you start drawing in corporations have particular perspectives on many, many issues, that cannot be right. So I am dubious about regulations of speech based on restricting private power. In that way, I'm consistent. I mean, I also have this deep suspicion that people who are suspicious of private power just care about their ox being gored. That when it was big, relatively conservative corporations that were doing it, the Democrats were at Twitter. Now that it's big tech companies that tend to lean left, the Republicans are at Twitter. And I'm just like, get over yourselves, is my general attitude towards this. I also have to make a point, which is you are right that Facebook has a lot of power, but it's not unlimited. There are multiple platforms. And I would add, I have a big problem with tech trying to force Parler to adopt their view. I mean, that strikes me as being a big problem, both from a First Amendment, it's not a First Amendment issue because private actors, but from free speech principles and antitrust law, frankly. I think that we should be doing everything possible to encourage a diversity of platforms. And that's one of the solutions, I think, to the private power problem that you express. And that thing, I really do think antitrust law is the more logical approach to the solution to the problems we face. But I also have to point something out, and this is important. Prior to the rise of cable television, CBS, Walter Cronkite, like Mark Zuckerberg, one guy, had enormous power over public opinion. And so this is not, and in many ways, much more so than Mark Zuckerberg, because there were far fewer alternative sources of information, and most people had no voice at all, right? I mean, we forget that until social media became big, which is really only a little over 10 years ago, most of us couldn't speak. We could create, create pages on the internet, but we didn't have audiences for them.
Right.
So it seems odd to me that we worry about Zuckerberg when we never worried about Walter Cronkite. And second, even today, and certainly in the 1990s, there's good evidence that shows Fox News has far more power over public opinion than social media. That in fact, if you look at, and especially if you look at studies of polarization, Fox News is a major actor. I would add that so is the MSNBC on the other side, but Fox News is the biggest driver on this. I assume that's a lot of private power, right? I assume you would not be okay with regulating Fox News. I would not be, to be clear, right?
Right.
And again, I feel like, well, why? What's the difference other than the box scoring issue?
Right. It's a great question. It's a great question. And actually, by the way, let me highlight the ox scoring point, because I do think it's a very important one that I think all of us should say, how would we react if Zuckerberg was a solid conservative, let's say? How would the left react in that kind of situation, right? And it is true. It is true that it used to be conservatives didn't much care about these things, and now they do. So, and again, you might also say the same about liberals. Here's a positive possible spin on ox scoring, and maybe both things are in play. Maybe it's a matter of learning, right? Maybe it's easy to be glib about, oh, well, just private power, what's the big deal? When you sort of intuitively feel it's kind of on your side, it's sort of mainstream and you're a mainstreamer. And maybe the classic thing is, the classic line is a conservative is a liberal who's been mugged, or conversely, a liberal is a conservative who's been arrested or has been improperly searched. Maybe it's not just a matter of hypocrisy. Maybe it's a matter that people learn. People say, well, wait a minute. This thing that I've wrongly used to kind of poo-poo and ignore, dismiss, now is actually something pretty serious. So I think that's one thing we should all keep in mind. A second thing is, you're quite right that it used to be that not just media, but especially the networks, the broadcast networks, had very, very broad power. Now, to be sure, there were 3 of them competing in the national TV space, whereas Facebook has the overwhelming majority of its particular niche. But TV was also its particular niche. But they also originated content, which was a special kind of power. So no doubt about that. Although note, the legal system was highly concerned about that. Remember, that was the era of the fairness doctrine. It was the era of the personal attack rule. There were limitations on ownership of local television stations. There were all sorts of things that were done. Now, a lot of it I don't like. I think the fairness doctrine is viewpoint-based and vague in various ways that I think the law ought not be. Personal attack rule, by the way, I think is much more defensible in some respects for broadcast. But in any event, there's nothing new with sensible mainstream people, left and right, in our legal system worrying about this very, very broad and very great and concentrated sort of power over public debate. That there was regulation, however misguided in some respects, of the broadcast networks. Because I do think this has been this concern about private power has been an enduring concern. Now, I don't know actually how Fox News and MSNBC would compare in influence to Facebook and Twitter. And especially, by the way, I think Facebook and Twitter are just beginning to really be to really influencing. A few years ago, they were trying to go after what's, one might say, very non-mainstream stuff. You might still say that's bad, but it was less likely to influence the next election. So I'm kind of projecting what they're likely to do based on what that's been happening in the last year or two. But I think that one important difference between a newspaper or a television channel and social media is newspapers and television channels have a tremendously important function of allowing people to deal with information overload. If you want to learn what's in the news, you want to read a newspaper, the whole reason you want to read the newspaper is for what it leaves out. The nonsense, the irrelevancies, and the like, as much as for what it includes. The same thing goes with a news broadcast. I would say the same thing goes with Google News. If you go to news.google.com, I would say the same thing applies to Facebook's recommendation feature, or whatever trending stories, things in the news, and so on and so forth. I think as to those, they really should have the discretion to decide what to promote. But for a lot of things, Facebook doesn't protect us or doesn't help us deal with information overload. Like if I go to your page, I'm going because I know I want to go to your page. And if they decide to remove certain things from your page, maybe that's good, maybe that's bad, but it certainly doesn't help me deal with information overload problem. Likewise, if somebody subscribes to Real Donald Trump on Twitter, back when there was a Real Donald Trump on Twitter, presumably it's because they want to see that. So I do think that functionally, this is also, by the way, the one way in which it's like a telephone company, that there was a common carrier obligation for telephone, and most certainly not, quite deliberately not for broadcast, because you can't have a usable common carrier broadcaster. But you can have a usable common carrier telephone company or post office, which has long had to deliver lawful but awful speech, or UPS and FedEx, which can't say, well, we think that bookstore is lawful but awful, so we just refuse to deliver from the communist bookstore or the KKK bookstore, what have you.
So I'm going to start with the post office because I think as a historical matter, I think you're wrong. the post office regularly refused to deliver stuff that was off, but that they didn't like. The Masses case.
Right.
Hans' famous opinion is about the post office refusing to deliver a
Right.
left-wing magazine, right? I mean, and that's an example of why this power, when it's in the hands of the government, is extremely troubling, right? Because that kind of selectivity by the state is just simply a way of pushing your own political perspective. Everything you say else is completely plausible, of course. And there is that you are correct. I would never claim that social media is the same as a newspaper because it's third-party content and it doesn't do a lot of filtering in the same way. It doesn't provide nearly as coherent a product. But I also agree with you that the fairness doctrine was terrible. And one thing I have to point out is what's funny about this is we are phrasing this as if the political right is unhappy with social media, the political left is defending it. This is not true, right? And if the one thing that Donald Trump and Joe Biden agreed upon during the 2020 election was both of them called to repeal of Section 230 at various points. I assume they weren't serious, either of them. I can never tell in a political campaign, but it's interesting. That was the one. There was it's hard to come up with anything else they fully agreed on, but that was the one, right? And if you ask Biden about Facebook or Mark Zuckerberg, his face turns red. It's not. And Erwin Chemerinsky, the dean at Berkeley, who's a very well-known liberal, recently called for using the fairness doctrine to basically imposing the equivalent of the fairness doctrine on Facebook, which I think is a terrible idea. I think the problem is that ultimately, private power is troubling, but regulatory solutions almost always are worse. I think that's why we have editorial rights in the first place. Is that I have many objections to the fairness doctrine, but one of them is if you look at right of reply statutes, when attack statutes, guess who they always protect? Not you, not me, politicians. Right? If you look at the statute in Florida, the deplatforming statute, who is Facebook prohibited from deplatforming? They can deplatform you or me, not politicians. There's a self-serving element, and I think the fairness doctrine very much served to serve the interest of entrenched politicians. I think that ultimately, I really do believe that the reason why I tend to be a fairly robust, just keep regulation out of it, I don't care. While I worry about private power, I worry much more about regulation and Citizens United, and I think that Section 230 stand for the same principle, is I just find it, I think that the risks are too high. And that's really the issue. And again, I concede that Fox is different from Facebook because Fox does provide a more coherent message over time, as did Walter Cronkite. But I do not believe that the problem of private power is really worse today than it has been in the last century.
Maybe so. I also agree with a very great deal of what you're saying. And I think the things I disagree with, I totally think that your position is plausible. I want to highlight a couple of small factual details. First of all, I agree the post office was indeed viewed as subject to the government's plenary control until basically the 19-teens and early 1920s, starting with the 1940s with the, I want to say, Hannigan v. Esquire case. The court suggested that wouldn't be so. And then in 1965 with Lamont v. Postmaster General, the court said, look, this is echoing Holmes's dissenting line in the 19-teens that as the government may give up the post office as whenever it wishes, but so long as it keeps it up, the right to use it is as much a right, part of free speech is the right to use our own tongues. That was Holmes's line, and I think that was, I think the court was right to shift to that, although of course the post office, unlike phone companies, unlike UPS and FedEx, is government operated. I should also add that the personal attack rule, as I understand it, was applied to anybody who was being attacked on broadcast, not just candidates, person or organization. I think the premise behind it, and maybe just wouldn't apply to social media platforms, but essentially back in the days of broadcasting regulation, people thought there's one sort of broadcast regulation, which is like the fairness doctrine and the personal attack rule. But really there were two. There was the regulation that 0.0001% of the population labored under, and those were the personal attack rule and the fairness doctrine. And there was the regulation that 99.9999% of us, the rest of us, labored under, which is it was illegal for us to broadcast.
Right.
So the theory was, look, if somebody is being given this special license to broadcast, then at the very least, if they criticize someone else who lacks that license, that other person should have the ability, which normally they wouldn't have, to at least briefly appear. That I think appear to respond. That I think is a not unreasonable position, although there may be problems with it. A fairness doctrine, I think, is much worse because it's much more likely to be viewpoint based and it can vague in various ways. But this ties into the thing which I totally agree with you on, which is there's virtually no problem that's so bad that it cannot be made worse by regulation. And the flip side is there are lots of problems that cannot be made better by regulation. And maybe this is one of them. Maybe on balance, this regulation is a bad idea. I guess my thought is, I'm not ready. I don't think it was a bad idea to impose common carrier obligations on phone companies, even though that means the Klan gets to use the phone lines and Antifa gets to use phone lines in order to organize its events and in order to recruit people. I don't think it's that bad an idea to tell UPS and FedEx that they can't say they refuse to deliver from evil bookstore. So I think that could be an administrable enough rule and a helpful enough rule to be useful, but I totally agree that it could just make matters worse and probably not terribly likely to make matters vastly better. Very hard to tell. So Ash, maybe I think I started, so maybe you can say whatever you want to say, and then I think there's time for questions.
On the fairness doctrine, you may be right. On the attack rule, I may be conflating the FCC's rule with the Florida rule that was
right. You're quite right about the Florida,
which was a politician-based rule. And that's a minor point. It's obviously reasonable people can differ on this, on whether or not. I do think, however, that there's a big difference between phone companies and Facebook, which is that when you pick up a phone, you call one person, right? It's private communication. Facebook is a open platform where people are communicating to lots of other people. And so the ability you can't really the phone can't be hijacked, right? Someone cannot, if people are making 1,500 obscene phone calls, it's not going to stop me from calling my mother. But platforms can be hijacked and eventually overwhelmed by bad material. And I do think that is why, even though, of course, I agree it was right to make telephone companies into common carriers. I should mention I was a telecom lawyer when I was before becoming a law professor. But I am dubious about applying the same logic to platforms. And I'm going to stop there because I agree we should move to questions.
Great. Well, thank you both so much for that. We'll start with a question from Will Atnip, who asks, could Congress explicitly condition Section 230 immunity on removal of disfavored but First Amendment protected content? So what that brings to mind for me is President Trump's lawsuit from this summer, the central theory of which was that big tech companies are First Amendment violative state action, because the government first granted them immunity, then, bringing them to Capitol Hill constantly, implicitly, one could argue, threatening them with punishment if they continue to allow disfavored speech on their platform, and especially as it pertains to President Trump, seemingly, as he would argue, colluded with them to choose him as a target for censorship. So I'll throw that to you both.
Well, I think we need to know a little bit more about what this condition is like. So let's take an example of something that I think is pretty clearly unconstitutional. You must remove anti-vaccination speech. Forget about whether it's true or false, just anti-vaccination opinions. You must remove them or else you lose your Section 230C1 immunity. Clearly unconstitutional. That's a viewpoint-based restriction, essentially. It's trying to coerce the entities into removing certain material. On the other hand, or not on the other hand, now let's make it not viewpoint based, but let's make it content based. Let's say that the government says you lose your 230(c)(1) immunity as to any material that you distribute that is pornographic. And let's assume that that can be clearly enough defined. I'm inclined to say that might be constitutional on the theory that the government essentially says, as to certain kinds of speech defined not by viewpoint, but by content, you get normal legal protections, which is to say First Amendment protections as a general matter, but not the extra absolute immunity of 230(c)(1). As to other things, the non-pornographic material, you get this extra immunity. That may very well be permissible. And in fact, is actually not that different from what currently happens under Section 230, where the rule is you have to remove copyright infringing material. To be sure, it's illegal material, but basically it means that you have to respond even to certain things, take down requests that probably some of them are going to be borderline and some of them may not be overt infringement. And if you don't, well, then you're liable under ordinary constitutionally protected, constitutionally permissible copyright rules. Whereas material that isn't accused of being copyright infringing, then you get absolute immunity for. So I'm inclined to say that something depends on the specific rule, and that it is possible that a content-based but viewpoint-neutral rule, at least of certain kinds, I'm not saying it's true for all kinds of subject matter rules, but at least a general enough rule, even though content-based, is permissible. But I'm not sure. It's an interesting and unresolved question. For the viewpoint-based rules, I think it's really pretty clear.
I actually would go beyond Eugene. I think that it is clearly permissible to say if you knowingly distribute unprotected material, you lose your immunity. In fact, Congress has already done that in the FOSTA-SESTA Act, where basically content that involves sex trafficking, if a platform knowingly distributes it, it loses its immunity. And that's, I have no doubt that's okay. I don't think you can do the same with protected content such as non-obscene pornography.
But I'm sorry, just to be clear, at least as I'm interpreting the question, let's imagine Congress were to say, if it's pornography, then you lose your 230(c)(1) immunity. You, of course, have whatever First Amendment immunities you might have. You just don't have 230(c)(1) immunity.
What does it mean to lose the immunity? So that you become liable for like defamation within the pornography?
Yeah, defamation within the pornography, or possibly child pornography within the pornography, which you are, but or if there's some negligence claim that you're depicting some dangerous sexual activity, you'd still have lots of First Amendment defenses as to that. And in fact, lots of pornographers distribute their pornography successfully because they have First Amendment protection. You just wouldn't have 230(c)(1) protection.
Maybe. It's not. I would have to think hard about that. It has to do whether we're getting into an unconstitutional conditions problem.
Right.
You're right. That is a legitimately hard question. But I mean, based on your reasoning, presumably one could also say you no longer have any C1 immunity with respect to any information regarding vaccines.
So that's why I wanted to flag this question as to what kind of content-based restrictions are treated as viewpoint neutral enough. Right. There's the long-standing question in First Amendment law that what kind of subject matter restrictions are so patently attempts to try to restrict a certain kind of viewpoint that we treat them as that. So the classic example is, let's imagine during the Vietnam War, in some place where viewpoint neutral restrictions are permissible, like in a limited public forum, the government were to say, you can't have any demonstrations about the war. No pro-war demonstrations, no anti-war demonstrations. To what extent would judges say, okay, I think we know what's going on. We're trying to suppress the anti-war demonstration.
But I agree with you, by the way. That's oddly enough, that's the hypothetical I use in my class.
Oh, there you go.
The line between viewpoint and content, except precisely that one, the Vietnam War. Though I think recently I updated it, the Afghan War, just to make it relevant.
Right. Good point. Good point.
But vaccines are different because there's tons of pro-vaccine content on social media.
Interesting.
Right? I mean,
you're right. I missed that.
Oh, it's different news feeds.
Right.
I get CDC stuff. I get my friends talking about how great vaccines are. This is a sign of the whole.
Got it. So they would still be liable. Like maybe if somebody gets some pro-vaccine messages that are too pro-vaccine and then they're injured as a result, they would be liable.
Or I post a pro-vaccine message and say that, and by the way, don't trust anything Eugene Volokh says because he's an anti-vaxxer. That's defamation, right? I mean,
right. Yes, it would be.
Interesting.
So a very interesting question.
And we have another interesting question. Sorry?
Ash, I think the next one's for you. Do
Okay.
you see it in the Q&A?
That's right. I'll read it out loud. So My friend Daniel Leeds asked a good question, directed at you, Professor Bhagwat, noting that you said that big tech regulation inevitably protects politicians. His question is, does it, given that he's actually from Florida, but the Florida law aims to protect political candidates from deplatforming, and Section 230, he argues, has helped protect big tech from facing any consequences for deplatforming a sitting president of the US. So how does Section 230, how does this whole conversation play into actual political campaigning and holding of office?
I think there may have been a misunderstanding of what I said. I wasn't suggesting that big tech protects politicians. What I was saying is that when people pass regulations of big tech, they protect politicians, right? So I'm not suggesting, obviously, I mean, the deplatforming of President Trump did not protect politicians, but it's notable that Florida did not choose to regulate Facebook's power to deplatform you or me. The only people that the Florida legislature protected was themselves, right? That was my point. And my sort of, this is my position. This is the same thing, whether you see Ash Bhagwat or Donald Trump. I don't think I have a right to use Mark Zuckerberg's property, right? I mean, in every other context, I would have thought that conservatives believed in private property. And you don't have a right, I don't have a right to use my neighbor's property. Facebook is Mark Zuckerberg's property. I don't have a right to use it. Donald Trump doesn't have a right to use it. Joe Biden doesn't have a right to use it. That's my position.
So I appreciate that. That's, I think, a very powerful argument. And usually I do support private property rights, although it's the rare conservative or even rare libertarian who thinks that private property rights are absolute in that respect. Let me ask you this question, and I'm not sure I know the right answer to this. So we know that a few states, including our own California, provide under the state constitution, under the state constitutional free speech clause, that private shopping malls have to allow visitors to come on the property, publicly open, publicly accessible property, and be able to gather signatures or hand out leaflets or what have you. Not sure, I would not have endorsed that rule myself, but I do think that's probably constitutional. The Supreme Court said that that's a constitutionally permissible, that state rule doesn't violate the First Amendment, but we can debate whether it's a good idea or not still. However, as I read the cases, Massachusetts and Washington went halfway or partway. They say our free speech clauses of our constitutions do not mandate access to private property, but our initiative and referendum provisions do. So what that means is that people have a right to go onto private property, not all private property, just the large block-sized shopping malls, and gather signatures for initiatives and referendums and for candidate petitions as well, and not for other speech. So I think that would be an interesting example of a content-based but viewpoint neutral rule, really quite viewpoint neutral. I think it's hard to sort of see a viewpoint-based spin there that does protect candidates and kind of politicians in the sense that it's even that it's politicians who back initiatives and referenda, even if they are grassroots politicians. Protect political causes on the theory that that kind of speech is something that the state should be allowed to promote further. Now, again, let's set aside the question of whether that's a sensible interpretation of the state constitutional provision and ask, do you think that that would be a First Amendment violation to say, to impose this kind of viewpoint neutral but content-based access rule? Pruneyard says a fully content-neutral access rule, you have to allow all leafleters and signature gatherers, is constitutional. Do you think the fact that this is content-based makes it unconstitutional? And I don't know.
I don't know the answer either. I think that's a hard question with respect to shopping centers. But this, we've already, we should share that we have debated this point before in another forum, so that sort of we both know each other's arguments. And the case Eugene was talking about is the Pruneyard case from about 1980. I think Pruneyard was probably correctly decided, but I don't think Facebook is a shopping center. I think that if you use, I think it's quite clear that what we know that if you extended the Pruneyard rule to newspapers, and the state said you have a right to publish letters to the editor in the New York Times, I am 100% certain that even a content-neutral access rule would be struck down. And again, I'm not claiming Facebook is the New York Times, or let's say the Wall Street Journal for this audience, but it's also not a shopping center. It's somewhere in between.
True.
Because it's open to the public and more like a shopping center, but it's a expressive platform. It's an expressive platform that is actually that moderates, right? That tries to create a user experience. And that I think is quite different. Shopping centers don't have, shopping centers, we talk about speech at shopping centers. I talk politics when I'm shopping. I was in a local shopping center in Walnut Creek, California last weekend with my wife, and we talked a little bit about politics. And Nordstrom's shopping center owner did not say, "Well, you're saying Democratic things, so we're going to kick you out, but we're going to allow Republicans to talk about politics." They don't draw those kinds of distinctions, right? They don't care because they're not expressive.
Well, so let me push back a little bit on that. My sense is that many shopping centers do want to create a particular sort of expressive environment. Of course, heavily focused on the commercial expression of themselves and their tenants, but also more generally the kind of environment that's conducive to people wanting to go and buy. And they have at times tried to curate speech in order to do that. Now, it's an interesting question why in Pruneyard they kicked out the leafleters. One possibility is maybe the owner didn't like that the leafleters had a pro-Israel message. Maybe the owner didn't like it. But another possibility is he probably said, quite reasonably, wait a minute, if I let these guys in with a pro-Israel message, I'd have to let in the anti-Israel people. And I have a lot of Jewish customers, and I might be that a lot of them would be offended by a militantly anti-Israel message. And by the way, his prediction would have been correct because the California courts since then have said that this is the rule really does protect everyone. What's more, after they said that, some shopping centers, for example, wanted to exclude anti-abortion demonstrators who were carrying around gruesome images of aborted fetuses. That's trying to create a certain kind of environment. The court said no. That violates our rule because our rule really requires you to be content neutral. Shopping centers wanted to exclude people who were organizing boycotts of their tenants. Perfectly reasonable perspective for the shopping centers because this is it's an economic interest, and they think it's quite unfair to require it to allow its property to be used to undermine its business. But California court said, nope, you've got to allow that other stuff too. So I do think shopping centers would like to be able to create a particular speech environment, very Catholic, very in a lowercase c sense, very broad-minded, but not unlimited. And California law doesn't let them.
Yeah, so to my mind, if you are correct, and I think you may be right, but to my mind, that just means Pruneyard is wrong.
Maybe right.
I think that
unanimously wrong.
Yeah, well, that's happened before.
It has.
Because you're right? It is. the logical place that this has gone to is the boycott speech and speech that would be that parents really would not want their children to be exposed to. And I could think of a lot of things that are protected, right? I mean, Cohen versus California. I mean, the word fuck is protected speech. I can be confident that shopping center owners do not want placards with that word on it, around their shopping center. If that is true, if they are trying to create an expressive climate that's basically spend money, don't think about anything else, then Pruneyard is wrong. That's the only conclusion, right? I mean, because what you're suggesting is we should extend the absurdities of the California doctrine to Facebook, a much more purely expressive entity. And that just seems to be moving in all the wrong directions.
That may be right. And, we're lawyers. We talk about analogy and precedent, but, sometimes one has to say just because the court screwed up once doesn't mean we should encourage it to screw up more. That's possible, very possible.
You know what? It's not obvious to me that Pruneyard would come out the same way today.
Well, it's funny you should say that. Certainly there had been talk of that, and then along comes Rumsfeld v. Fair.
Right.
So Rumsfeld v. Fair, Congress says to universities, which are totally free speech actors, who have a lot more ideology the typical university does than I think the typical shopping mall. It says you have to allow military recruiters to interview on your property. And in fact, you even have to kind of include their coordinates, like they're in this room at this time, in your general mailings and the like, if you want to get government funds. Now, you might say it's government funds, but this court says that's constitutionally permissible, and it would be even if it were a categorical mandate that universities must allow military recruiters to recruit on their property, even though they introduce all this evidence about how they disapprove of the military because of its anti-gay and lesbian policies of the time, that various students disapprove, that they want to curate an environment of inclusiveness and non-discrimination, and the very presence of the recruiters undermines that, and certainly having to include the recruiters in their recruiting fairs and various other things undermines that. Unanimously, the court says that's perfectly fine. Yeah. So it's hard to see how Pruneyard would then come out the different way, given how Rumsfeld came out.
Oh, I disagree. I think Rumsfeld is a very different case. Because I think that the expressive aspect of allowing a recruiter onto campus and announcing when they're recruiting is really low. It really doesn't, it has very little hijacking capacity. And remember, because many law schools used to do this, this is a non-issue, by the way, because of course, military no longer does exclude LGBTQ people. But when they did, there were always people outside protesting, students, which is permitted. And there were always some event elsewhere in the law school saying, we don't approve of this. So I think that the Rumsfeld was about, it's simply not plausible in my mind that when law school, because it's really about law schools, right? No one else was doing this. If law schools permit recruiters onto their campus, that they're in any way endorsing them.
Yeah, but why would anybody think that if Twitter permits real Donald Trump onto its platform, that it's endorsing him? Again, never mind whether it's promoting him as kind of a Twitter feed you may want to follow. Just endorsing him. In fact, if anything, it seems actually quite close to Rumsfeld and less intrusive than in Pruneyard, because in Pruneyard, the worry was that the people would come up to strangers and say, "Oh, sign our leaflet, petitions and such." But here, real Donald Trump is like the military recruiters. They're there for those people who want to go see them. And nobody would think that it's Twitter endorsing it. And if they did think that, then I think they would equally think that it's the university endorsing it. And if Twitter wants to disclaim endorsement, it could do the same. It could do the same thing the universities did.
I don't want to get too far into the weeds on this, but I'm going to very briefly answer you. I think the reason the difference is that universities and law schools, I'm going to focus on law schools because that's where the action was. Law schools have essentially no gates on who gets to recruit on campus. and I mean, they just didn't, right? I mean, there were no ideological preferences. Twitter and Facebook have very clear sort of rules about what they're trying to provide an experience that is curated against certain kinds of speech, violent speech, nudity, hate speech, all protected by the First Amendment. But they're trying to create an environment that is curated in such a way as to exclude all of that protected speech. I think that they're much more active than I think you are giving them credit for. But I think, how late does this go?
I think we're done.
Okay,
Am I right?
so I'm happy to take one more question, but then I need to probably head out. So
Yeah, I'd love to throw one more to you both, if you would. We've kind of danced around the idea of common carriers. We haven't quite mentioned public accommodation, but wanted to call your attention to Justice Thomas's concurring opinion in Biden versus Knight First Amendment Institute from earlier this year, where he pointed out, I think, the relatively common sense intuition that these, regardless of it being private property, some kind of antitrust notions come into play, and just private concentrated control over online platforms that the public largely, hasn't always been around, but now that it is, has come to rely on. So to what extent, and again, you've addressed it somewhat, but in closing out, I'd be curious to hear both your thoughts on the applicability of common carrier and public accommodation law to these questions.
I can answer that in 2 sentences because it's pretty clear from my position that would be flatly unconstitutional, because just as Congress could not convert the New York Times into a common carrier, I don't think it can convert platforms into common carriers by fiat. I also think it's a terrible idea, because why do we want to open Facebook up to pornography and hate speech and all sorts of other things? A funny story about this, though, I should add. When Brett Kavanaugh was on the DC Circuit, he wrote an opinion arguing that internet service providers like Comcast have editorial rights. He and Thomas are this far apart on this issue. They're in opposite wings, right? And so one thing to be aware of is that the conservative bloc on the court is not at all united on this. They're in fact fundamentally divided. And I think Kavanaugh Kavanaugh's wrong as to ISPs, but I think he would be right as to platforms.
Right. So I agree with Ash that it doesn't really matter if you call it public accommodation law or common carrier law. The question is, setting aside how 230 should be interpreted, the question that we've been discussing is, does the First Amendment secure to service providers the same editorial discretion as to their hosting decisions? Again, never mind their promotion decisions, but their hosting decisions, the same editorial discretion that say the newspaper gets, or does it secure to them as little editorial discretion as a property owner gets? Such as the owner of a shopping mall or the owner of a university. And I totally agree with Ash that platforms are somewhere in between. The question is, where in between? And that's I think, the issue that courts are now beginning to struggle with. So I think with that, we're done. And Ash, such a great pleasure as always. And many thanks to the Federalist Society for inviting us.
Thank you for having me. This was great. It's really fun.
Thank you both for joining us, and everyone in the audience, please clap in your apartments and join me in thanking our 2 esteemed guests for enlightening us and enlightening our evening. For all you out there, in 2 weeks, we'll reconvene for debate about the Supreme Court's upcoming concealed carry case. I know I can hardly conceal my excitement for that one, but sadly, I'll have to carry forward that excitement to October 20th at 1 p.m. Good night, everybody, and thanks again, panel.
Thank you.